So then the argument becomes under the convention, is Part 11 of UNCLOS, the seabed mining chapter, all customary international law? Has it somehow crystallized to customary international law that then would bind the United States even if the US hasn't ratified the convention? Now, my thoughts and opinion on that is absolutely not. Anyone that would suggest that would be the case would get an F grade in my law of the C class. It doesn't take into account the very fact that if you watch any of the International Seabed Authority meetings, if you go to any of the informal informals of the ISA and you listen to states parties to the convention can't even agree on what these articles under Part 11 mean. So how could you possibly have state practice and opinio juris for an emerging part of the convention, an emerging regulatory regime where states parties can't even agree with what these terms mean? There's no way that it could be as a whole seen as customary international law.
Hello and welcome back to the Elements of Deep Sea Mining. My guest today is Nathan Eastwood, a partner at Watson Farley and Williams, and one of the few lawyers who has worked both inside the International Seabed Authority and alongside companies navigating its rules. In this conversation, Nathan explains the legality behind the U.S. issuing its own deep sea mining licenses in areas beyond national jurisdiction, how that collides with the ISA's position, and what's at stake for companies, governments, and the future of multilateralism.
The cornerstone of international law is state consent. You cannot create rights and obligations on a sovereign without that sovereign state's consent.
If you've been confused by claims that U.S. actions are illegal under UNCLOS, or if you just want to understand better how international law works when it comes to resources beyond national borders, please stick around for this deep dive conversation with Nathan Eastwood. Okay, we're rolling. Welcome to the Elements of Deep Sea Mining podcast. Nathan Eastwood, thank you for being here.
Thanks for having me, Eric.
I want to start with your background and tell us who you are, where you come from, and how you got expertise on international law and deep sea mining.
Yeah, no, for sure. Nathan Eastwood, I'm a partner at Watson Farley Williams. We're an international law firm based out of London, but we've got offices all around the world. I'm fortunate enough to lead our public international law practice here at the firm, which has us doing a range of different advisory, regulatory, contentious, non-contentious work. So it keeps us all quite busy. But how I got into the world of seabed mining, I have always been a contentious mining lawyer. So when I started out, straight out of law school, I started working on mining disputes. Typically, it was acting for Australian mining companies bringing claims against sovereigns, so other states. So where you have Australian investors building, let's just say, a gold mine in Thailand, the Thai government might take adverse measures in relation to that project, which might breach international law. And under various treaties, you can actually hold that state to account and actually commence arbitration proceedings against that state to enforce those rights for that investor. And I was doing my master's in public international law at the University of Sydney and was studying law of the sea and came across Part 11 of the convention, the deep seabed mining chapter, and started learning about the international regulatory system under UNCLOS as to how private companies can apply for contracts at the International Seabed Authority, how the system works, how they require state sponsorship, et cetera, et cetera. And I just saw so many parallels between the work that I was doing on a contentious and non-contentious domestic mining front with overseas projects and what may exist one day under Part 11 of the convention in terms of exploration and exploitation of mineral resources in the area. So I then just kind of pivoted. I mean, I just got really fascinated by the legal issues that arise, Part 11 itself, the International Seabed Authority, and completed my master's in international law, and then started doing some work for the International Seabed Authority originally. And I did a little bit of work for them, and then I was fortunate enough to take a sabbatical from my firm that I was at the time and actually get to go and live in Kingston, Jamaica where the ISA is headquartered, for 12 months. And I was the legal officer for regulatory affairs, and had the responsibility of working with the Legal and Technical Commission to finish and assist them in finishing their work on producing the phase 1 standards and guidelines that were accompanying the exploitation regulations. I finished my time at the International Seabed Authority, went back to the firm, so stopped my sabbatical, and then pivoted. I decided to stop doing work for the regulator, the International Seabed Authority, and start using my skills, experience, and expertise to assist the contractors, whether that be applicant contractors, whether that be contractors that already have contracts, whether that be sponsoring states, whether that should be future sponsoring states that might want to put in place their national implementation regulations to sponsor an application in the future. So I've been doing that work ever since. I've been in this space for over a decade. I teach seabed mining at the University of Sydney. I also am completing a PhD at the University of Sydney, looking at the dispute resolution rights for contractors as well.
Wow. So you are well sunk into this topic and have come at it from all sorts of different positions. I think that's interesting. I'm sure you can't get into any of the details, but what kind of work is there being done in terms of companies engaging with ISA statutes? I guess what I'm wondering is there contentious legal cases going on all the time around these things that we don't hear about? And what do those kind of look like?
It's a great question. So I guess firstly, I should say that any opinions I share today as well are my own opinions. They don't necessarily represent the opinions of my clients. They don't necessarily reflect the views of the U.S. government or any government for that matter. They're purely my own opinion. But in relation to whether there's lots of these contentious sort of disputes yet that no one knows about, the answer is really no. The way the Seabed Disputes Chamber is set up under Article 187 of the Convention, it would require public hearings. There's a public registry at ITLOS based out of Hamburg. ITLOS is the International Tribunal for the Law of the Sea. So if there was any contentious dispute proceedings commenced at ITLOS or before the Seabed Disputes Chamber, the public would know about it. It would be disclosed. I think it's starting to get it's warming up or getting contentious, I would say, or I think that's a fair way to put it. In my opinion, the ISA is well and truly past its deadline for adopting the exploitation regulations. They're mandated to do so under the convention. They have set 2 deadlines, which they've missed. So they were self-imposed deadlines after Nauru pulled the trigger under paragraph 15C of the Part 11 implementation agreement, which when Nauru did that, it gave the ISA 2 years to complete the adoption of the exploitation regulations. Something I think helpful to in mind, and for the listeners, it wasn't like there was no work done and then Nauru pulled the trigger and the ISA only had 2 years to get the job done. There had been a very extensive draft document that had been put together by the Legal and Technical Commission, had been through multiple rounds of stakeholder consultation over almost decades, well in excess of decades, really, putting this document together. So it wasn't like Nauru pulled the trigger and no work had been done, and it was like 2 years isn't enough time. But anyway, separate to that, the ISA did miss those deadlines, that 2-year trigger deadline. It missed 2 self-imposed deadlines. And then at the recent council meeting that took place in July, the council actually failed to adopt any new aspirational date in which that they will adopt the exploitation regulations. Now, that becomes really contentious for ISA contractors. It puts them in a very difficult position because they get a 15-year contract, exploration contract, and they're required under that contract to move to exploitation. So when the contract expires or is about to finish, you have to apply for an extension, and you've got to explain to the ISA why you haven't been able to move to exploitation. But of course, you can only imagine these sort of operations, even exploration activities, exploitation activities, are very expensive activities to conduct. And you've got to raise significant amounts of money to do so. If you're a state, it's a bit different because you can get money from Treasury or the ministry or whatnot to conduct the activities. But if you're a private contractor and you've got to raise money to do these activities, it's incredibly expensive. It's incredibly difficult to do so in circumstances where a lot of investors see the ISA route as having significant regulatory risk because the ISA seems to be not able to adopt the exploitation or find consensus to adopt the exploitation regs. becomes even more problematic because recently the council started asking the Legal and Technical Commission to name and shame non-compliant contractors. So there is some contractors that are starting to be named and shamed because what the ISA is saying is, well, you gave us a 5-year work plan and you're not delivering on what you were meant to do under the 5-year work plan. And then that contractor is saying, well, hang on a second. You can't adopt the exploitation regulations. It's very difficult to raise money when you're not even meeting your own mandate under the convention. Why should we be putting more money into this? Because we're just putting money down into a black hole, really.
So there's a feedback loop between the legal certainty of the environment, of the international environment, and the abilities for contractors to do the things that they are required under the legal regime to do.
That's right.
So I think it's worth maybe just giving listeners who don't think about this very much a bit more grounding in why international law is important from the perspective of commercial entities. I think that this ties into what you said you worked on before you got into seabed law, but when I think some people think, well, how is it fair that a company can sue Thailand for breach of contract when this company is going over there and extracting Thailand's resources? Like, how is that fair? But I think it's worth it to explain to people why this is important.
Yeah, no, for sure. So it might make sense for me to explain it in the bilateral investment treaty, free trade agreement, terrestrial mining sense to start with. And so what a bilateral investment treaty is it's a treaty between two countries which set out various protection standards. So it tells both countries agree that it will treat foreign investors from each country in a certain way. So it will guarantee things like we won't unlawfully expropriate the investment. We'll treat the investment fairly. We'll give it a fair and equitable treatment. We'll make sure that we do any due process in relation to our regulatory actions, things like that. There's various investment standards that are included in these treaties. The whole reason these treaties existed or will come into existence, or one of them, was to encourage inbound foreign direct investment in states that were seen as risky jurisdictions. So you had these treaties come out or start to be penned in the 80s and 90s, where you had big foreign investors, usually from Western states, moving into jurisdictions, let's say in Africa or Southeast Asia or elsewhere, where rightly or wrongly, there was a perception that there would be a high level of regulatory risk or sovereign risk in investing in that country. And what you don't want to occur is if there was a change in government or the government just changed its position in relation to a project, you didn't want to be in a position of, say, having to sue Thailand in a Thai court because you're as a foreign investor, you're probably not likely to get a very good outcome. Whereas if you could bring an action enforcing your rights under the treaty before international arbitration, you would then be heard by an impartial tribunal, and sort of some of the risk or concerns in relation to going before the domestic courts would be alleviated. If you're successful before international arbitration or a tribunal, you get an award that can then go be enforced in other countries against the assets of that state that you sued. So why it exists or why is it fair? It all comes back down to the cornerstone of consent, state consent, which we'll talk a lot about, I think, today with you. And that's these two states got together, consented to give these rights to foreign investors that came in. And one of these rights was the ability to sue them. So that was a system.
And that's in everybody's interest. So if we're sticking with Thailand says, I want you to come in and invest in resource development in my country. And investors say, well, I don't know, I'm not feeling secure with the existing just domestic security legal situation there. Thailand says, okay, well, here I'm going to, Thailand will sign a contract, sign a agreement with your country that is now enforceable internationally. So then there's this additional agreement. So everybody's getting something that they want.
So usually the treaty's already signed. So states will go on in the 80s and the 90s, and even now, like states go out and negotiate these treaties with each other. It's not usually because of the existence of a project that they'll go and sign.
Yeah, of course. But I just want people to understand for people who I don't think about this, I want them to understand that it's really in everybody's interest.
Yeah, and these states, particularly the ones that are developing, don't necessarily have the skills or expertise or necessarily even the capital to start some of these very expensive projects. So they often need to bring in foreign investors in order to get the capital and actually get the project off the ground. Of course, they'll charge royalties, taxes, and take benefit from the project as well. But it does. I mean, it benefits the state because the state gets this project, gets the royalties, taxes. The foreign investor benefits because the sovereign risk is mitigated, which helps them raise more money from banks. And then if things go pear-shaped, there's a dispute resolution option that's outside the domestic courts.
Okay, sorry, carry on then.
And then we see it again in Article 187 of the convention, which in the contracts that the ISA signs with contractors, it actually references those provisions, which then again allow a contractor, which can be a private company or a state, to bring an action against the International Seabed Authority in relation to a dispute in respect to that contract. So in my opinion, there is various options for aggrieved contractors, even at this stage, to potentially bring an action against the International Seabed Authority for unlawful delay in the adoption of the exploitation regulations.
And is this related to what you're working on for your PhD project?
Yeah, so my PhD is looking at essentially assessing all the different parts of Article 187 because there's various dispute resolution options. Member states can bring an action against each other. A member state can bring an action against the ISA. An applicant contractor, so not even a contractor with a contract yet, can actually bring a dispute in relation negotiation of the contract against the ISA. An existing contractor can bring a dispute. So there's several different streams of potential disputes that can arise under Article 187. So I'm looking at that. Under Article 188, there's also an option to go to UNCLOS arbitration, which is a different. It's still international arbitration, but it would be governed under what's called the UNCLOS rules. That would look very different from the Seabed Disputes Chamber because typically UNCLOS arbitrations are held in private. So that would look a little bit different. And then my PhD also looks at what could potentially be seen as a carve-out in relation to the Chamber's jurisdiction when it looks at discretionary powers the ISA has. So I'm covering quite a bit. And given everything that's happened in the last 6 months, 12 months. I mean, I've technically been working my PhD for 3.5 years, but so much has happened in 3.5 years in this space that I'm constantly pivoting on what I'm researching or what's going to be most material for when I finish it.
Wow. Well, I mean, it sounds like you're working on a lot of different things outside of your PhD also. And as someone who is also I'm just doing a PhD and a very small podcast, and I feel overwhelmed at times. So impressive on how many irons you have in the fire and how much you are managing to get done. So obviously, I think the main topic we're going to talk about in this conversation is the U.S. position in granting or potentially granting exploration and exploitation permits under their own national statutes as opposed to going through the United Nations processes. I think I'm really very happy that you have agreed to take the time to explain this because there's lots going on here. And I think that you've got a position that I don't often get access to. So I'm really keen to get your explanations and a bunch of the nuance on this. But maybe a good place to start is just what is the US actually doing? Where do we stand right now before we kind of get into the arguments for or against whether this is legal, whether this is a good idea, but what's actually happening?
Yeah, so what's happening? So back it would have been last year, there was an announcement that there was a executive order that was released by President Trump in relation to what was called, I'm just going to get the exact name for you so I don't misquote it, but Unleashing America's Offshore Critical Minerals and Resources. And
this was in April, yeah.
Yeah, sorry, this was in April earlier this year. And what the intention of the executive order was to expedite the process for reviewing and issuing seabed minerals licenses and commercial recovery permits under DSHMRA. And so DSHMRA is the US statute that you referenced earlier, but it stands for the Deep Seabed Hard Mineral Resources Act. The DSHMRA has been around since these. There's been several US exploration licenses that have previously been issued to US companies under DSHMRA. It has been some time since new licenses have been issued. However, it would be incorrect to paint DSHMRA as being some form of outdated or historic statute that is basically full of dust or it has been irrelevant, as some people have suggested for some time. And I say that because even under the Biden administration, so before President Trump, there were certain US licenses that were actually renewed under DSHMRA. So it's not like the original US licenses that were issued to US companies and then the act's never been used since. The regulator, which is NOAA, the National Oceanic Atmospheric Agency, or administration, I should say, they have been renewing, even very recently, renewing US exploration licenses. So what I find really interesting is that the, I guess, noise that has happened since April in relation to, firstly, Trump's executive order, and then the announcement by the metals company that they were intending to submit an application under DSHMRA, I personally have been a bit shocked by, because these licenses have been issued and renewed by NOAA under DSHMRA by various and consecutive US administrations, both Democratic and Republican, with little or no opposition by the International Seabed Authority. And in fact, you have, when you look at the license map of the International Seabed Authority, you see sort of large gaps in that map where the US licenses actually. So I'm not aware of any, I know there's no formal agreement between the International Seabed Authority and the US in relation to not issuing licenses over each other's areas, et cetera, et cetera. But there was almost like, I sort of saw it as a acknowledgement of each other's regulatory rights, and they weren't issuing licenses that were going to be competing with each other in that sense.
So, I mean, I think I'm one of those people who found this like you say, this wasn't very surprising to you because I think you're obviously very aware of these things existing. I was very surprised I was kind of exposed to the deep sea mining question in the Norwegian situation, which was trying to develop regulations to to allow deep sea mineral activity within Norway's area. And then when I heard that, the US has had these regulations for such a long time, that was complete news to me. And I think a lot of people didn't kind of realize that this is something that had been established for a long time. And then, so I understand why people are surprised. I think that it has a lot to do with just kind of not knowing what's been done, what's out there. And I'm really, again, happy that we've got you to put in some of this information. And then my kind of take, and I want to hear your reaction to why DSHMRA and the ISA license areas kind of match and everything, and their wording matches, is that they were kind of parallel regulation systems that were available to be merged at some point. It's like, well, Lockheed Martin is now sitting on licenses that were granted possibly before the ISA had, but early on. And so it doesn't make any sense for the ISA to go and potentially grant those same areas to somebody else, because the idea is that, well, these two things will someday become one thing once the details that are keeping the US from signing and ratifying UNCLOS get worked out. So I don't know how you see that or have a different kind of take on that.
Yeah, I mean, I don't necessarily see it in a way that the ISA were leaving it open in the hope or expectation or understanding that the one day the US would be joining UNCLOS or signing and ratifying the convention, and therefore it's becoming a states party and a member of the ISA. I don't see it in that sense. And I think even recently, and don't quote me on this, but certainly within the last 10 years, the ISA has a regulatory tool called APEIs, and they're called areas of particular environmental interest. And they're essentially national parks that get set up to ensure that no contract can ever be issued by the ISA over those areas. And the ISA, in relation to one of the APIs, part of that API actually sat over one of the existing US licenses areas. So there certainly seems to be a trajectory or a movement in which the ISA, at least, is not just sort of leaving the US licenses in the hope that the US is going to one day join the convention and therefore be a member state. I think a couple of the other important points to make, and just to touch on what you mentioned at the start of the question, was that DSHMRA did come into place and was adopted in law before the current version of the exploration regulations at the ISA. And I think what's really helpful for your listeners to know is that when they're hearing or being told that what Trump is proposing is like the wild, wild west, or that it's unregulated, or that it's basically a rubber stamp and that's it, the point I'd want to make is that the actual exploration regulations under DSHMRA are virtually exactly the same exploration regulations that the ISA adopted. So my understanding is the ISA actually took DSHMRA, modified it slightly, and then adopted the exact framework as the exploration regulations at the ISA. So it's not the case that you've got the wild, wild west and that there isn't going to be stringent oversights, or there's not going to be proper due diligence done, or there's not going to be scoping of environmental impact assessments done or environmental impact statements done. It's actually regulatory detailed and onerous as the ISA regulations. And I think that's something that's really important for your listeners to know, is that it's still regulated, and it's regulated to the same standard as the ISA.
And then, like the ISA, there aren't any actual exploitation regulations developed.
No, so that's not correct. That's not right. So DSHMRA has both exploration regulations and commercial recovery regulations. So rather than calling it exploitation, the US calls it commercial recovery, but there are actual already adopted exploitation regulations, commercial recovery regulations under DSHMRA. So unlike the ISA, where you've got all this regulatory uncertainty because you don't have exploitation regulations adopted, and it appears that the ISA Council can't find consensus on adopting it anytime soon, you have a US pathway which has adopted regulations.
Okay, so that's super helpful. I wonder why I didn't know that kind of thing. But so because I'm aware, so TMC has applied for exploration as well as recovery permits. They put in both applications. And there's this, I'm not sure what the status is, but there's a public comment period on some text that is floating the idea of somehow combining this exploration and recovery application into one process. I don't know this is outside your scope, I'm sure, but I'm not sure if you can give any idea why there is that proposal to combine these things. From my perspective, it seems unnecessarily inflammatory, and also I didn't really see the point, given that, well, TMC has put in two applications. So what's the point of streamlining a process that seems to be fairly streamlined at the moment? I don't know if you've got anything to add there.
Yeah, so the thinking behind it is that it was always a placeholder within DSHMRA which actually foresaw a consolidated application pathway. So NOAA, in its recent proposed amendments to its rules, which is what is currently going through public stakeholder consultation, was referring to that placeholder as the hook that it was using to now put together the consolidated application pathway. I think where it's relevant is in situations where you have an applicant entity that has already conducted sufficient exploration work in relation to the proposed commercial recovery area. Rather than, and we can use the metals company as an example here, in circumstances where you have an entity like TMC USA who has, or it's actually TMC Inc., the parent entity, has conducted significant exploration work in a certain part of the ocean and gathered significant amounts of data, etc. They wish to or are ready to put together a commercial recovery application. The idea is that you could have both applications considered at the same time, and that you could have then both a exploration license and a commercial recovery permit issued under the same application, as opposed to having to go through the exploration license permitting process, get the exploration license, and then literally the next day, you would then submit a commercial recovery permit application because in your view as the applicant, you've already got sufficient data and demonstrated the technical and financial expertise necessary to move to commercial recovery. It's a way for expedition and for both applications to be heard together. Whilst I use the word more expeditious, I don't want to imply to any of your listeners that it's any less onerous or that there are regulatory steps that get omitted. It is still a fairly lengthy regulatory review process. There is still every single element that would be required to be conducted under separate application pathways are required to be conducted under the single application pathway. So you still have initial compliance checks so that NOAA will receive the application, deem it to be substantially compliant. Then there might be some questions or to and from to make sure that it complies with DSHMRA. So then you get issued a full compliance letter from NOAA. Then what happens is the certification process, where the application is distributed amongst various federal agencies of the United States. They review the application, they liaise with NOAA, they raise any concerns. There's questions that get bounced around, there's a review, et cetera, et cetera. During that certification process, the US Attorney General is also involved. Departments like the State Department are involved. There's also the Antitrust Review Board that is involved. So there is a lot of dialogue between different US federal agencies in relation to the merit of the application and how it may align with federal agent policies. And then they relay that back to NOAA. If that passes, the application is certified. Then after certification, what's really interesting here and where I think it's actually potentially arguably more environmentally protective is in the US, it's actually NOAA that prepares the environmental impact statement, the EIS. So unlike the ISA, where the contractor prepares the environmental impact statement, in the US, the regulator actually prepares the environmental impact statement. So after certification, the NOAA will prepare the EIS. And then after that stage, NOAA releases the draft EIS and the draft terms, conditions, and recommendations, the TCRs, to the public for public stakeholder consultation. There can be public hearings, both formal and informal, heard in relation to the application. And then following that stage, after NOAA receives all the comments, NOAA may eventually issue the license or the commercial recovery permit. So it's not like a review process or a regulatory system without teeth. It very much has teeth, and it mimics what happens at the ISA.
Yeah, this is, I mean, as someone who doesn't spend a lot of time in the details of regulation, I'm often kind of just wonder about the starting and stopping point. So you've detailed now all of these different things that have to be done, and whether you split it into one or into two, I mean, I'm still a little bit like, okay, I understand it's more expeditious to have it in one. I don't really see why. It sounds like all of those things are going to have to be done either way. I mean, someone has said, okay, well, Trump made an executive order asking for these processes to be streamlined, and so this is just a response to that order. This is an attempt to streamline the process without removing any of the content. If they haven't removed any of the content, as you say, then that's great. It's interesting also that you point out that this is for companies that are in the situation that the metals company finds itself in, of having done a whole bunch of previous exploration work. Because now that you say that, I realize that the metals company is not the only company in that situation. There are a lot of other companies that have also progressed quite far along the exploration stage.
Yeah. And then this then creates this existential crisis for the International Seabed Authority, because you potentially have a situation where the ISA contractors realize that the ISA Council will not find, or in the short, medium, or even long-term, consensus to adopt exploitation regulations. They've got all the environmental data from 20 plus years worth of exploration work. Equally, they could incorporate in the US, set up a US subsidiary, and apply through DSHMRA. And then it raises a question an existential question as to the relevance of the International Seabed Authority.
Well, okay, so before we dig into the fallout of a world without a relevant International Seabed Authority, let's talk about, I guess, just the legality of what the United States is doing. So I think this is one of the issues that people are raising here, is saying, okay, this isn't right, but more than that, this isn't legal. But just, yeah, maybe if you can touch on the different ways, the different issues that are being raised here in your response to them.
Yeah, no, for sure. I mean, we could spend 2 hours doing this, but I'm going to try and succinctly do it and give my thoughts and views. I mean, it's interesting in the sense that when this first when it all kind of came out, and you saw the statements that were made by member states at the ISA, and even recently, Madam Secretary General of the ISA just saying this is illegal and unlawful. Nothing much more is explained other than just saying it's illegal and unlawful. So it tends to be the position, or at least as I understand it, the ISA's position is that Article 137 of the convention and essentially applies to non-states parties as well as states parties. So that the only way activities in the area can be conducted in compliance with international law is through Part 11 of the convention. Whether or not you've signed and ratified the convention or not, it applies to you. That's how I interpret the ISA's position, and I would say several of its member states, not all of its member states, because not all of its member states have actually publicly said this, but at least that's what we're hearing from Madam Secretary General of the ISA. The US position is that it is never signed UNCLOS, it has never ratified UNCLOS, it is not a state's parties to UNCLOS, and as such, it is not bound by the regime under Part 11. The US considers that seabed mining is an exercise of high seas freedoms, and that it is allowed to, pursuant to those high seas freedoms, it is allowed to conduct activities in the area outside of Part 11. The US has, in recent statements at the ISA and at the meeting of UNCLOS states parties in June of this year, clarified its position in this regard. I won't read the statement that the US gave at the ISA or gave at that meeting to your listeners, but to the extent they want to read the US position, I'd highly encourage them to do so. So if we unpack that a little bit, I mean, what's my opinion? Where does all this sit? Who's right? Who's wrong? Et cetera, et cetera. The cornerstone of international law is state consent. You cannot create rights and obligations on a sovereign without that sovereign state's consent. It's the cornerstone of international law. So when you've got how is international law created, how are these rights and obligations imposed on states, you really sort of have three main forms. One is treaty law, one is customary international law, and one is called jus cogens. So treaty law is sort of fairly self-explanatory. If you have two countries that sign a treaty, or you've got a multilateral treaty, multiple states that sign and ratify that treaty are bound by it. That's how countries that have signed UNCLOS, or states that have signed UNCLOS, are bound by the obligations contained therein. And when I say signed, I should say signed and ratified, not just signed. Some of my friends and colleagues say, well, that don't share the same opinion as me, say, well, hang on a second, the US signed the Part 11 agreement, even though it hasn't ratified the Part 11 agreement or the convention, it's nevertheless signed it. And under what's called the Vienna Convention on Law of Treaties, once a country signs a treaty, they are not meant to take steps which will oppose the objects and purposes of that treaty itself. However, how I respond to that is that Article 4, subsection 2 of the 1994 agreement actually spells out in what circumstances a state can even give its consent to be bound to the Part 11 implementation agreement. And it says, and I'll quote it, that no state or entity may establish its consent to be bound by this agreement unless it has previously established or establishes at the same time its consent to be bound by the convention. So the US has never signed the convention, it's never ratified the convention, it's never given any consent to be bound to the convention. So even the terms of the Part 11 agreement don't allow a state simply to be bound by it by signing unless it actually signs and gives its consent to be bound to UNCLOS at the same time. The US never did that. So I don't I don't accept and I don't agree with the argument the mere signature of the US to the 1994 agreement has somehow magically created rights and obligations on the US to only conduct activities under Part 11 of the convention. Because if that was the case, arguably, why is the US not a member state of the ISA rather than just being an observer state? Presumably, they would have been granted a seat by now as a member state. So I don't agree with that interpretation. It's good to see the discourse kind of evolve from that. I think the vast majority of my colleagues and things that I read at the moment don't seem to suggest that the US is bound by just the mere signing of the 1994 agreement. So it's good to see that's kind of slipped away.
Mm-hmm.
The second way that the ISA or my friends and peers argue that the US is nevertheless bound is what's called customary international law. So for your listeners, customary international law is when there's no treaty in place, but there is a custom of what's called state practice and opinio juris in relation to a certain norm that is emerging that states believe that they're bound to comply with. So it's not written down, it's not in a treaty, but it's a emergence of a norm or a course of conduct in relation to what's expected of states that's emerging, and a significant number of states recognize that norm, which is the state practice element, and also that there is agreed opinio juris or consensus of the opinio juris that they're bound to comply with that obligation.
Do you have an example of that from somewhere else in international law?
Yeah, so I mean,
what's an international custom that exists?
Yeah, so the Vienna Convention on the Law of Treaties, to the best of my knowledge, it didn't even get enough signatories to actually come into force, but enough states recognize that the terms of the Vienna Convention on the Law of Treaties as to how you go about interpreting treaties reflects customary international law, and they believe they're bound to comply with it. So how states fulfill their obligations under international treaties, or how you interpret treaties, which is detailed in what's called the Vienna Convention on the Law of Treaties, is recognized as customary international law. So then the argument becomes, under the convention, is Part 11 of UNCLOS, the seabed mining chapter, all customary international law? Has it somehow crystallized to customary international law that then would bind the United States even if the US hasn't ratified the convention? Now, my thoughts and opinion on that is absolutely not. Anyone that would suggest that would be the case would get an F grade in my law of the sea class. It doesn't take into account the very fact that if you watch any of the International Seabed Authority meetings, if you go to any of the informals of the ISA and you listen to states parties to the convention can't even agree on what these articles under Part 11 mean. So how could you possibly have state practice and opinio juris for an emerging part of the convention, an emerging regulatory regime where states parties can't even agree with what these terms mean? There's no way that it could be as a whole seen as customary international law. However, what I think needs to be done, and where there potentially is scope for further analyses, is whether certain sections of Part 11 have crystallized as customary international law. One pertinent one being Article 136, which is the common heritage of humankind principle. And what really needs to be done is, rather than these statements that Part 11 is custom, a surgical approach by those asserting that needs to be done to explain why it's customary international law. It's not sufficient enough just to go, well, it's in the treaty, and so therefore it's custom. You actually need to show the state practice and to show the opinio juris.
So yeah, okay. So you're saying that this concept of customary law, it doesn't just apply to text that exists, but that text has to be used, worked, understood somewhere for that to be customary. It has to be a customary interpretation of the text. And then I like what you're saying about a more surgical approach. So this would mean that instead of saying, well, U.S. is forbidden by customary law to have its own regulatory regime. It's like, well, actually, the U.S. is okay to have its own regulatory regime, but because this benefit sharing portion or whatever is customary law, then the U.S. needs to incorporate that into its benefit sharing regime. Just one last question on that. Is it possible that there can be a kind of customary law that is generally accepted, except for one party objects and kind of takes themselves out of that? Like the customary law is for everybody except for this one party because they've been consistently objecting.
Yeah, so that's what I now was going to talk a bit about. So even if you were to say Part 11 of the Convention is custom, or that certain aspects have got enough state practice or opinio juris, as I said, I don't agree with that position, but even if that was the case, there is a doctrine of what's called the persistent objector under international law, where if a state objects to, at the time of the emergence of the custom, or the norm becoming customary international law, it won't be bound to that state. The state won't be bound to follow that rule. So the US argues that it has always been and has remained a persistent objector to Part 11 of the Convention. And its position on that is in relation to comments and statements that it made at the time that UNCLOS was negotiated. So it made certain statements. Also, there has been certain statements made by US administrations to the US Congress in relation to always being a persistent objector, and that the US has always considered that activities in the area was the exercise of high seas freedoms, and that it would not be bound by Part 11 of the Convention.
Okay, so you kind of listed off the top. There's treaty law, customary law, and then there was a Latin.
Yeah, jus cogens. So the third source of international law is what's called jus cogens. Jus cogens are a norm of international law of which there can be no derogation. So you can't even be a persistent objector to a jus cogen. A jus cogen is essentially rules that are considered so fundamental in nature as an international community of which there can be no derogation. And there's very few jus cogens that have been recognized, but they relate to crimes against humanity, prohibition on genocide, prohibition on racial discrimination, prohibition on slavery, human trafficking, and torture. So they're seen as sort of such core principles of who we are as humanity that there can be no derogation. And so Part 11 of the Convention has never been recognized as a jus cogen, and in my view doesn't rise to the high level required to be considered a jus cogen norm.
Okay. Then okay, so then the next question I've got here is kind of in this international legal disagreement that the US and the ISA / others may be heading into, where are the teeth? What remedy might the ISA have against the USA? How might this play out?
Yeah, so this is something that I was discussing as recently as last week in Copenhagen. I think a key takeaway for your listeners here is that I think it's very unlikely that the ISA is just going to wake up and agree with the US, and I don't see anytime soon the US going, "Oh yeah, we were wrong. Let's get rid of all these licenses, and let's not do this." So there's obviously tension, and as a dispute resolution lawyer like myself, we usually go off to courts and tribunals to resolve the tension and to get a decision. The interesting thing here is there is no court or tribunal with jurisdiction anywhere to resolve this dispute. There is no court or tribunal that would be able to make a ruling or stop the US from issuing licenses or commercial recovery permits to US citizens. This is because, as a non-state party to UNCLOS, the United States cannot be brought before the International Tribunal on the Law of the Sea. It could also not be brought before the Seabed Disputes Chamber, and it arguably also could not be brought before any of the other dispute resolution bodies that are mentioned in UNCLOS itself. The second court that is quite often referred to that resolves international disputes is the International Court of Justice. The International Court of Justice would not have jurisdiction to actually hear a dispute against the United States because the United States withdrew from the compulsory jurisdiction of the International Court of Justice, I believe in the late 80s after the Nicaragua case. So again, this cornerstone of consent under international law, you can't drag a country or a state to an international court or tribunal unless it's given its advance consent to do so. Given the US wasn't a state party to UNCLOS, those bodies are out the window, and the ICJ has withdrawn its consent. So there's no international court or tribunal to resolve this. Where I think it may go, and this is what I expect will happen, is that people that feel disgruntled, whether it's NGOs, whether it's whoever it is, may seek remedies within the courts of the United States. So should NOAA issue a license to an applicant, an NGO or aggrieved individual may commence judicial review proceedings to challenge the issuance of the license or permit on the basis that it breaches the United States' obligations under international law. Now, the issue that my thoughts on that is that the prospects of success of such an application would be incredibly low because a US court is not going to apply an international treaty to a dispute against a US agency in circumstances where the US has never even signed that treaty. US courts have also, there's not a large amount of jurisprudence where international courts have even accepted or applied customary international law, especially in circumstances where you've now got persistent and consistent practice by the US over several administrations, both Republican and Democrat, persistently objecting to be bound by Part 11. So I don't see a US court applying it as custom. And I think this is the Trump argument, for lack of a better word, is that you've actually got a US statute, DSHMRA. So a US court has to apply US law. And in this circumstances, you've got US law. So I don't see that action being very, very successful for aggrieved people in the US either.
What about more kind of real, like a more political approach? Do you see that like there's no court to take this to, but how does this, what other factors are there in international law? Do states lean on one another and kind of say, you know, okay, you didn't sign this thing's important to us, we're going to put some alternate pressure on you and try to get you to come around?
Yeah, so it's a great question, and one that is now really starting to see the light. So I think, in my opinion, those opposed to the unilateral action of Trump or the US administration, I think have accepted they can't take the US to an international court or tribunal. And I think that they've accepted that the prospects of success of challenging it domestically in the US would be low. So now what I'm hearing is references to Article 137 of the Convention and Article 139 of the Convention suggesting that entities which are domiciled in UNCLOS states parties that are suppliers or investors in TMC USA, if they were to do that, would cause their states to breach the convention. So let's not start. I can stop talking about in hypotheticals. Let's talk about real life examples. So if we look at, there's been, I think, recent articles or maybe past speakers on this very podcast, or there has been some recent journal articles that have come out suggesting that, for example, the CSIRO, which is Australia's independent science agency, who conducted work for the metals company in relation to independent assessment or putting together of thresholds and indicators on how the marine environment could be protected from serious harm. These individuals, like on your podcast or that authored these articles, were suggesting that Australia has breached its obligations under the convention because the CSIRO have assisted TMC with potentially supplying data or information that will encourage or support its activities in the area outside of the convention.
Yeah. I haven't. I think it's clearer with the All Seas example because All Seas is going to be likely to be a more active participant. I feel like CSIRO, now we've got an extra level of, okay, but what do we mean by assisted? Whereas all seas or the metals company are more directly
Yeah.
involved and
I mean,
easier for people to
I'm
represent
happy
around.
to speak to the all seas example and put it into context. I again don't agree that that all seas supplying a vessel to TMC USA causes Switzerland to breach its obligations under UNCLOS. And the reason for that, and the two articles that quite often get cited by my friends and peers, is Article 137, subsection 3, which talks about that no state or natural or judicial person shall claim, acquire, or exercise rights in respect to minerals recovered from the area outside of Part 11. Now, all seas are not claiming, acquiring, or exercising rights in respect to the minerals recovered. The right holder is TMC USA. That's the holder, assuming that they get a license and they're the ones out there doing that. The right holder is TMC USA. It's not all seas. All seas is supplying a vessel to TMC USA. So I don't accept that interpreting Article 1373 in good faith and in accordance with its object and purpose, the object and purpose of the convention, under the Vienna Convention on the Law of Treaties, allows for that interpretation. I think it's excessively wide, and I don't agree with it.
But sorry, go ahead.
The second one that is often referenced is Article 139 of the convention, which talks about that state parties shall have the responsibility to ensure that activities in the area, whether carried out by state parties or state enterprises or natural persons which possess their nationalities, shall be done so in conformity with this part. And so the argument is here, or the suggestion that's being made, is that again, all seas is carrying out activities in the area which is outside of Part 11, so therefore triggering the obligations of Switzerland as a potential breach by Switzerland under the convention. Now, I also don't agree with that interpretation because, again, all seas is not carrying out activities in the area. Activities in the area are defined as exploration and exploitation of the area, the seabed and the subsoil. All seas is a supplier of services to TMC USA. TMC USA is the entity that is carrying out the activities in the area. So that's just giving it a textual interpretation, but also considering 139 in its context and also how 139 has been understood to date and how it's been opined on by the Seabed Disputes Chamber in the advisory opinion on the roles and responsibilities of sponsoring states. 139 has always been considered as the provision that would require sponsoring states to put into place implementation legislation, domestic legislation, to ensure that their nationals are carrying out activities in the area in accordance with UNCLOS and the ISA. So it was to ensure that there was this due diligence obligation on sponsoring states, that they would have to implement this national implementation legislation, and that they were under this obligation to ensure that entities that were sponsored, that were domiciled within their jurisdiction, would conduct their activities in accordance with the convention. That's how it's always been considered, and I don't agree with this very wide interpretation that is emerging. I don't think it accords with the Vienna Convention on the Law of Treaties. I don't think it interprets the words in good faith and in light of their object and purpose. And I also don't believe, even if we went to the travaux preparatoires of the actual article itself, I don't believe that the working papers or the travaux support such an interpretation either.
Does that leave open the possibility for Switzerland or Holland, whichever is the relevant government in this case, to put a law on the books that says, referencing ISA, we forbid any of our nationals to aid companies who are pursuing deep sea mining outside of UNCLOS or something?
Yeah.
Like there's a step that could be done by a government that would then kind of have that effect that you say isn't currently
Yeah,
there?
of course. I think so putting aside what the treaty text says and what that might mean, a country is free to do what it likes, really. So if Switzerland or the Netherlands decided to adopt a domestic law which said that, they're free to do so. I mean, if the Parliament of the Netherlands or the Switzerland decided to vote in a new law which said exactly that, they're allowed to do that. That's a domestic initiative of that state that would apply to entities domiciled in that jurisdiction.
Okay, then the other question I have about this particular set of teeth is, so you've kind of said it doesn't look like policies would qualify because they're not actually taking possession. I didn't catch the specific wording
Claiming,
there,
acquiring, or
minerals.
exercising rights in respect to minerals recovered is the terminology.
Rights to the minerals, but then what about the argument that this is going to really limit the potential market for these minerals? Because if the international community says, okay, all of these minerals have been acquired outside of whatever we're considering to be the legal means, you can have them in the US, but the moment you try to sell them elsewhere, they're kind of illegal minerals.
Well, my opinion on that is, to the best of my knowledge, there's nothing in the convention that would what prohibits that. I mean, the relevant articles that get brought up all the time is 1373 and recently Article 139. And when I look at 1373, it is limited to claiming, acquiring, and exercising rights with respect to minerals recovered in the area. If nodules are harvested from the CCZ and get taken to the United States for processing, or to Japan, for example, Japan is not, or PAMCO is not claiming, acquiring, or exercising rights with respect to minerals recovered. They're processing the nodules.
But if I buy those minerals and put them into if I'm an electric vehicle battery company in Japan or in Norway, and I buy those minerals, at that point, I'm claiming rights to them. If I'm going to sell you a car that has minerals in it, I have to have the rights to those minerals at the point that I'm going to sell that to you.
Well, I don't think it extends that far. I think it extends to the claiming, acquiring, or exercising of rights with respect to minerals recovered has to be done in relation to, in accordance with Part 11. I think there's an argument that once the minerals are recovered and then processed, I mean, arguably it already falls outside of the competence and jurisdiction of the convention anyway.
So you're saying that the rights acquired kind of refers to the process of mining.
It is linked to the carrying out of activities in the area. If you look at the Travo and the working papers to these provisions and the negotiation documents, then they were not intended to extend this far. They were intended to ensure that the carrying out of activities, so under Article 139, it's the act of the actual exploration or the exploitation. It was not meant to be interpreted as extending so far that you would have the nodules processed, and let's take the copper, for example, that might be derived from the nodules, could then not be, no off-taker from a state party of the convention could then off-take those minerals to then put them in batteries to then sell to, let's say, Australia, and then Australia can't accept an electric vehicle that has copper in it that's come from seabed mining. I mean, I think that is a creative interpretation and extension of these articles that those opposed to seabed mining are adopting, but I think it's not honoring and interpreting the words of the treaty, and I don't believe their interpretation would be supported by the Travo of the text either.
I'm noticing time is moving. I want to cover a few of the more kind of big questions, but I guess maybe before we get off of this particular topic, what has been the ISA response so far? Do you have any more details in take on?
For sure. I mean, the ISA's response so far is that at the recent session in July, the council adopted a decision in which the council requested the Secretary General to investigate contractors for non-compliance of their contract and the applicable law in relation to potential activities that are being undertaken outside of Part 11. So, and if you listen to the meetings that were streamed online, And I unfortunately wasn't in Kingston in July. Usually I'm at every session, but I wasn't there for this one. But I understand the informal informals that happen away from public eye. It was very much focused on, and as a result of TMC USA's application before NOAA, and in my opinion, a wish by the ISA to slap TMC on the wrist for taking such action, which the ISA considers is illegal and unlawful under international law. So the councils requested the Secretary General to conduct that investigation and then report back to the Legal and Technical Commission. The Legal and Technical Commission will next meet in March, and the councils asked the Legal and Technical Commission to report its findings to the council in March. Now, in my opinion, this is going to become very contentious, and as a former legal officer for the International Seabed Authority, I would be recommending the ISA tread very carefully, because even at the starting gate of this, there appears to be an excess of jurisdiction in that council decision in tasking the Secretary General even to commence the investigation, because the Secretary General does not have that competence or power under UNCLOS to be fulfilling an investigatory function. That function lies squarely with the Legal and Technical Commission. So even from the get-go, there's certain question marks as to the lawfulness of the council decision. I don't think comments by the Secretary General calling this illegal and unlawful is necessarily helpful and raises real questions of due process. For example, if she is carrying out the investigation, which I understand has yet concluded, potentially not even commenced yet, and already making such a determination, I think you really raise this question of due process.
That makes sense.
It does. It does.
I mean, it's interesting, not to get into the kind of two sidesism of this, but people have been talking a lot about the importance of due process lately in the U.S. domestic story, which we all internationally follow probably more than is healthy. But yeah, I mean, we all are aware that due process is important. It's important not to say that things are legal or illegal. The role of the Secretary General is in this case, but I think it's always really interesting when the kind of arguments that one side is really familiar with get kind of put in front of them from a different position and say, okay, are you being consistent with your principles, even in situations where you don't want them to necessarily apply?
Yeah, so it's going to raise various interesting issues, and I think the biggest issue is that the ISA only has competence to assess the obligations of the counterparty to the contract. So in TMC's case, you've got NORI and TOML are the ISA contractor entities. So the ISA only has competence to apply a penalty to NORI and TOML, because they're the counterparty of the contract. So the ISA can only look at whether what NORI and TOML have done has been in accordance with the applicable law. In my view, piercing the corporate veil and looking at the actions of a completely different company, so it's not even the parent company of NORI and TOML, it's a different company in the entire corporate chain, would go too far, and it wouldn't be in accordance with contractual law or just general principles of contract law to hold the actions of a completely separate entity attributable to NORI and TOML and say, okay, well, NORI and TOML, you've somehow breached your ISA contracts because of the activities of a completely separate company. And I think where it then gets really interesting is if the ISA does do something with the NORI and TOML contracts. This goes back to where I sort of started this podcast when I was talking about investor-state arbitration and the work that I have done before I got into deep seabed mining. You arguably, and in my opinion, could have an unlawful expropriation of the investment, because NORI and TOML, if these contracts are terminated, they will lose their contract areas. And if the expropriation is unlawful, which I would say it was because the ISA didn't have competence to pierce the corporate veil and penalize those entities, you potentially have a situation where NORI and or TOML could bring an action against the ISA for damages. And those damages could be fairly significant.
That would be at the end of this investigation, which has been requested depending on the findings of the investigation.
Yeah, so this is all subject to, of course, like what the ultimate finding of the investigation is, what the ISA does, whether they actually do cancel, penalize, whatever they do with the NORI and TOML contracts. I guess all I would say is I think the ISA needs to be very, very careful.
Interesting. Nathan, I want to be mindful of your time here. I guess just briefly, if I have two more questions for you, it would be kind of what is the best case and the worst case scenario here? If you can look forward, like what do you see as a good outcome, and then what are the outcomes that we should be concerned about? And let's take the best case first, and then I want to put kind of what I'm concerned about for the worst case outcome and hear your response.
I mean, the best case outcome for me, I mean, despite what your listeners might think from the views I've shared on here, I'm actually a huge believer in multilateralism. I love the UN system. It's what I loved about international law in the first place. I mean, I loved the geopolitics of it all. I do believe that multilateralism works, but at the same time, I don't forget really cornerstone general principle of international law when it comes to state consent. And we can all hope as much as we want that, or believe that the ISA was going to be this one system that would have either the customary power or the UNCLOS powers to just regulate this for everybody. And I think the US, in my opinion, demonstrates by not being a non-state party and also through the persistent objector will not be bound. So I think the best case scenario is that we are going to see a world where the US will issue licenses and commercial recovery permits. All of the other states' parties are going to be subject to the ISA. So I think the best case scenario is the ISA actually does meet its explicit mandate under the convention and adopt exploitation regulations to stay relevant. I want the ISA to be relevant. I do believe in the work that it does, and I do believe in the sharing of data and deep data and the opportunities for developing states, because that's so important. The ISA system in Part 11, this whole sponsorship arrangement where you would have potentially had countries like Nauru or Tonga or Kiribati or Jamaica, these developing states that couldn't have participated previously, benefiting from this sponsorship system was really special. And I want to see the ISA maintain and be relevant. But I think we need to be realistic. And I think the best case situation is we're going to have ISA permits and licenses. We're going to have US permits and exploration licenses. And we are going to potentially have operators operating in the same parts of the ocean. When that happens, Article 87 of the convention says that they need to show due regard to one another. So when you're exercising high sea freedoms, you have to show due regard. What that actually means in practice, there's been little judicial authority on, but that will need to be worked out. And in the best case scenario, we have some form of MOU or something that is signed between the ISA and the US in terms of benefit sharing. And so that the benefits that come from these resources, as it states in the convention, as potentially it is recognized under customary international law, belongs to all of humankind. And then there is one system of benefit sharing.
Yeah, this, I feel like I can hear people reacting kind of that they don't want this pressure campaign by the metals company trying to bypass the ISA because the ISA has been dragging their feet. I think some people are going to say, well, no, don't let the metals company push us around. The ISA's got to go through its process, yada, yada. And it's just, I feel like it's a possibly a situation where we don't want the perfect to be the enemy of the good. We are in a situation which, and this will, I think, get to the question of the worst case scenario, is I'm at least worried about the potential risks of dissolution of international cooperation. So I hear you saying, okay, well, the best case scenario is everybody takes this as a serious issue, gets themselves together, works hard on this, and gets us to a place where it is a stable, perhaps jurisdictional approach, but is stable and workable for everybody. And whether or not that was brought to pass by this pressure by TMZ, however people think about that, that's probably the best outcome. But yeah, then I want to hear your thoughts on the risk of the dissolution of international cooperation, because this is where my, well, whatever personal concern has kind of been triggered by this is, okay, I don't like to see at a time when we are more and more reliant on international cooperation in all sorts of society. I don't like to see places where it seems to be breaking down. So what do you think?
Yeah, I mean, it's a great question to ask me. I mean, will it the worst case, or will it break down into sort of international discooperation? I mean, I think there is if that's to happen, I think it will happen because of China. And I think because China has more contracts than anyone else, and they are ready to go. I mean, I think they've got they put in their environmental impact statement to conduct their test mining under their exploration contracts fairly recently. They're about to start that, if not are undertaking that as we speak. I'm not sure, but they will not want to wait. And then if you see if China and others in the let's call them the pro-DSM camp, see that they can't find consensus within the ISA to adopt a regulatory framework, there is, of course, then a risk that they will just do it themselves. And then you have a system where you have exploitation activities taking place without regulations.
Yeah.
And that's not good. But I mean, I have to say, in my personal capacity, it is deeply disheartening having gone to so many ISA sessions and watch a very small number of states successfully almost bully the rest of the room in not progressing these negotiated for years and years and years. They have working modalities which are deliberately hijacked, I would say, to cause further delay. There is just a deliberate effort to, in my opinion, delay as long as possible and stop the adoption of these regulations by a very small number of states. I think the vast majority of states accept that they're under a legal obligation to adopt these regulations and do work hard. There's a small number of states that are very successful in lobbying with NGOs and stopping these regulations from being adopted. And what they're risking then is activities taking place without any regulations, which is not good.
Yeah, no, it makes me feel. I mean, I guess my personal inclination to try to encourage people towards cooperation is a little bit the reason why I started this podcast, and I'm very grateful that you've come on to lay out a different perspective than I've been exposed to before, and hope that people, whether or not you feel that some other side is acting rightly or wrongly in this debate, that recognize that this is potentially quite important, and cooperation is important. We kind of have to get past our whatever grievances and work together. I guess I'll save my soapboxing for another time. Nathan, I feel like I've got a lot more questions I could ask you. Is there, I mean, one of which would be kind of, what's your experience of being in the deep sea mining conversation? I just, as someone who's been in it for so long, I'm always interested to hear people's take on that, but we can save that for a future conversation. I don't know how much time you've got.
No, I'm happy to answer that. Maybe it's a nice way to finish as a final question. I actually find it really challenging. Like, personally, I find it quite challenging. Came across this sector, this emerging sector, 15 years ago, and I saw it as something that could really change the planet. And when I say change the planet, I mean for good. I mean change the planet for good. We're needing to transition to clean energy. We always talk about the need for more batteries. We're doing renewables. Everything when it comes to creating the batteries or products that we need to be captured, whether it's solar panels or the wind turbines or whatever it is, we're crying out for more of these metals and minerals. And here we have this resource which, at least for a non-science person, because I'm not a science person, I'm a lawyer, looks to be less impactful than terrestrial mining on land, when you see huge amounts of deforestation and you see, all these horrible things happening in Africa and Indonesia, and you've got these nodules that are sitting unattached to the floor of the seabed that could be harvested and taken to shore for processing, etc. And so what I think I really struggle with working in this space is that I think it's quite clear the obligations of states from the treaties. It's not overly complicated in what they were required to achieve, and the fact they need to adopt these exploitation regulations. And yet I think it's hard for me to watch, as someone that is such a huge fan of multilateralism, to go to those Jamaica meetings and just watch what really looks like 3 or 4 states bully the entire room and not see progress. And as well, I think it's, and seeing certain, former officers of the International Seabed Authority sort of being slammed in the media. I mean, I featured in a New York Times article as well, someone slamming me and saying bad things about that I apparently allegedly did, which were completely not factual. And it's just this, I think anyone that seems to be in one camp or another, it just seems very hostile between each other, which isn't great. And you don't get anywhere by being hostile with each other. Like, to your point, we've got to learn to cooperate and share sides and see where we can find agreement and move the discussion forward.
Absolutely. Well, then, I think that's a great place to wrap up. So final questions are, where do you point people who want to know more about this? Any publications or resources where people can dig into more of specifically the kind of legal questions that we've been discussing here?
Yeah, no, for sure. I think the first thing I'd recommend people do is to go read the U.S. statement in relation to their obligations under Part 11 of the Convention. So that should be, I believe it's up on the ISA website. So you're able to get a copy of that. And I'd encourage people to read that because it explains their legal position in depth. There's obviously a lot you can just read by sort of Googling seabed mining and seeing what comes up. But if you're looking for sort of the other side of the coin, my firm, Watson Farley Williams, we've done a seabed mining article series. So you can read up on those articles as well and look at sort of our opinions on some of the legal issues as well. And then as well as we mentioned earlier on, I'm currently writing my PhD in looking at dispute resolution rights of contractors, and we'll be publishing further articles in the near future. And I also, I believe, have an article coming out fairly shortly. I think it's in the Cambridge Journal of International Law, looking at space law and seabed mining law, and looking at the lessons that can be learned from one another.
Okay, I'll put links to all of those things. I hope when your Cambridge article comes out that you'll ping me and I can repost to anyone who follows me. Where do listeners follow you to keep up with your exploits? Where's your social media presence?
LinkedIn. Put me on LinkedIn. Always happy to have more followers. And of course, you can see further details about me, what I'm up to, on my Watson Farley Williams profile on the firm's website. You can also contact me via email. My email is neastwood@wfw.com.
Okay, great. Okay, Nathan, thanks so much for your time today.
No problems. Thanks, Eric.